Now we're going to be turning it over for our Open Meetings Act training to Frank Johnson, the Deputy City Attorney for the City of Gaithersburg, and April Ishak, the City Attorney for Havre de Grace. Welcome,
Okay.
April.
Can you hear me now?
April, I think you're still, okay, there we go.
Okay, good.
Okay, well, I'm assuming I just want to make sure I can be seen and heard.
I can see and hear you.
Yep.
Okay, if you, April, then if you can, I think we're good. Well, welcome everybody. We will go ahead and get started. This is going to be discussing complying with Maryland's Open Meetings Act. In fact, although we're talking about open meetings, a lot of the discussion will be about closed meetings. That's just by the nature of the beast. April Ishak is the city attorney for the city of Havre de Grace in Harford County, and she's the former chair of the Open Meetings Compliance Board. So she's somebody who knows a bit about what she's talking about. And I'm deputy city attorney for the city of Gaithersburg. We both want to thank Ann McNeil, who's the Assistant Attorney General with the Maryland Attorney General's Office, who is counsel to the Open Meetings Compliance Board, and has been behind the scenes as well as a co-trainer for many years, and is really the main person who has put together the PowerPoint and reviewed updates over time. April may have a couple of comments, but as we get started, but as we go through this, now sometimes it can be a 90-minute training, but we're going to go through at a pretty good pace because we've done this before. So hopefully we'll be efficient. But we want to point out that this is guidance. This is not legal advice. Certainly check your own local attorney, city, town, county attorney for specific advice, because you may have there are certain requirements locally for open meetings that go above and beyond what the Open Meetings Act provides. The other thing is, while this discusses certain reasons you can close meetings, just because you can doesn't always mean you should. Sometimes doing so does run the risk of raising questions about something, but there really isn't any reason to have a question. You certainly do want to close for confidential matters. My last comment as we get started is just for the required open meetings credit. You do need to be logged in for the entire live session. Just watching a recording like an account, and you will need to complete an online evaluation form within the following 3 days, and that should be provided. Certainly, if not, check with the Planning Commissioners Association that set this up, and they should be able to get that to you. And April, I don't know if you have any intro to offer as we get started.
Oh, all I wanted to add is thanks to you for your great work in presenting this program before, and I look forward to working with you again, Frank, and also kudos to Ann McNeil, who's also been very instrumental in getting this material together.
Yes, and part of what we're going to be, well, we will move to the next slide, please. There we go. Just in terms of covering the objectives, we're going to talk about what is the Open Meetings Act, why you need to comply, and then what does it require? What are some of the activities that are covered? What's it require before, during, and after a meeting? Because there are some specific requirements there, and then we'll talk about enforcement. Let's also face the reality that we have been in a crisis for some time. There were some who expected, oh, by June or July, we'll be all finished with this and be able to move on. Well, maybe they didn't specify the year. Maybe that was the problem, but we're still working with it. So we have guidance included here, and I should say with Ann's help on that in that regard as well, that when the public can't personally attend, how do virtual or online meetings comply? Because the Open Meetings Act still applies no matter what. And we will touch on that in some detail as we move through here. Next slide, please. And so this is the Open Meetings Act. It is part of the General Provisions article, which doesn't sound too exciting, but Title IV, I believe it is, has the Public Information article, which is also something that we have to deal with. So there's a lot in General Provisions. It's Title III of the Code. And as we go through on certain specifics, we're going to give you the citations just so that you're aware, and hopefully you will, I believe the PowerPoint will be available so that you can have this as a guidance later on if you have a specific question that comes up. Next slide, please.
Okay, so the legislative policy statement, which is on the prior slide, states that the performance of public officials is important to be observed, as well as the deliberations and decisions. So if you go into this determining whether the Open Meetings Act applies to your particular situation, those are the things you should look at and consider whether it's appropriate under those circumstances that the meeting be open to the public, and whether it's within the intent of the Open Meeting Act. So as Frank previously stated, it's always better.
And could we have the prior slide, please?
Yeah, thank you. It's always better to err on the side of caution, looking at what the purposes are. So I always find that starting with the purposes of the act in mind when you're making the determination of whether the meeting is subject to the Open Meeting Act, that kind of gives you a good starting point. Next slide, please. Thank you. So there are basically three things to do when you are going to comply with the Open Meetings Act. The first is before the meeting. What do you need to do before the meeting? The Open Meetings Act requires prior advance notice of the meeting and an agenda. During the meeting, you need to hold it and be open to the public. After the meeting, you need to prepare minutes and make those available as well. Make sure that your public body has designated a trainee who is familiar with the Open Meetings Act and its requirements. And next slide, please. In-person meetings are not always required, as Frank alluded to, with the current COVID-19 restrictions for in-person meeting. You can't always have people in the meeting. That does not mean that the Open Meetings Act does not apply. Whenever a quorum is available to meet and discuss public business, that's when the Open Meetings Act kicks in. The public is required to observe or listen to the deliberations. The board has held that conference calls are permitted, and this has also been upheld by the Court of Special Appeals. So you can be rest assured that as long as you're meeting the other requirements of the Open Meetings Act, if you hold your meeting by a telephone conference call that is available to be heard by the citizenry and by all the participants, that would be in compliance. It must be accessible to the public, and the public must be able to hear all comments and discussion. Any more comments on that one, Frank?
I would say the main thing is that conference calls have been approved, and maybe just moving into the next slide. Based on that, we believe that virtual meetings following the same rules can also comply with the Act. The most critical element is that these meetings have got to be accessible to the public. It doesn't mean in person. That was the main point, and it was the, as the slide before showed, really there was a Court of Special Appeals case that where the court found in 2011 that that a conference call, actually it was one member who was conducting, participating by conference call. They found that that was entirely appropriate. And the board has held that conference calls, as long as they're accessible, that is, as long as somebody knows how to dial in and listen, can work. And I can speak from experience, certainly in the city of Gaithersburg, even prior to the crisis, there are times when there's not sufficient time for a board to necessarily, on a specific issue, call together every member for an in-person meeting. So you conduct a conference call and you do get notice out to the public so they're aware. And we'll talk about notice in a bit. So in terms of virtual meetings, a virtual or online meeting that satisfies these requirements can comply with the Open Meetings Act. That means electronic online, Zoom, Skype, webinar, online webinars, Google Hangouts. It is possible to do in person and then allow live feed for remote public observation. There are different ways to do this. We do strongly recommend including the conference call option. And there are a couple of reasons for that. It may work better for people without a computer. It demonstrates that you are maximizing the opportunity for people to participate. But also, let's face it, things go wrong, as the year 2020 seems to show us across the board. Certainly when you're dealing with electronics and computers and connections and Wi-Fi, things go wrong. And for somebody getting cut off, the conference call may not be perfect for them, but can be the option to still allow them to still participate. And that can also apply to board members for that matter. One point there at the end, this is important during the COVID-19 crisis, but we are finding increasingly that this also, in some ways, using the virtual platform, can broaden access, because in the past, for somebody to have to come down to City Hall or the county office building for a meeting is a bit more inconvenient at times than simply logging in. So it may be that when the crisis is resolved and it is safe to handle the in-person meetings again, that some element of what we'll be discussing as part of today's presentation will still, simply because it makes sense, continue to be part of how we conduct public meetings. Next slide, please. And so as we said initially in the introduction, we're going to go through what's covered. So the first thing is you have to be a public body in order for the Open Meetings Act to apply. There are a couple of elements of that. Multi-member, that means more than one member, of course. And as a general matter, at least two non-employees. So if you have simply a task force made up of city or county employees, that's not going to be subject to the Open Meetings Act. But if you have two members of the public who are not, and they can be whoever, can be a business owner, can be somebody else, at that point, then the act would apply. Some other elements, some measure of formal creation, that can be law, charter, resolution, can be by executive appointment. By that, it means the chief executive for the local government or somebody subject to their policy discretion. What about subcommittees? Well, if it's a formally created subcommittee, sometimes it's by the same policy direction, such as a resolution saying, well, we create the following subcommittee. That subcommittee is going to be subject to the act. If a subcommittee is created that is just informal by the committee, it's possible it wouldn't apply. Now, if the subcommittee consists of a quorum, that's not going to be a way to get around the act. The act's going to apply anytime a quorum of members discussing public business is occurring, then it's going to apply. But let's say you have a 5-member committee, and let's say you have a 7-member committee, and you create a subcommittee of 2 or 3 people. If it is informally created by the commission and not referenced in the formal document, then that may not be required to be an open meeting. When I say may not, it may depend on the specific circumstances. You have to look at each situation. But other coverage, informally created public bodies, certainly if it's created by the chief executive or government or the government entity or somebody subject to the policy direction of the chief executive, and some private corporations. There are certain non-public, there are certain public corporations that are essentially set up to be assistants for local governments that can assist, for instance, with parks funding or some other elements, and where the boards are appointed by the local government, well, those are going to be subject to the Open Meetings Act for their meetings. Next slide, please. And in terms of talking more about what's covered, so we've discussed the public body. Now, what is it that they do that would be covered? Well, it's a meeting. What's a meeting? Any deliberation, consideration, or transaction of public business. That's an important element. Simply sharing information is not necessarily going to cross the line, but when you have deliberation, and certainly when it's a transaction of public business, and there's a quorum involved. Now that means a quorum convened, but it can also mean a quorum that happens to be present in a room. The PowerPoint notes cycled through a room to evade the act. We're not necessarily accusing anybody of trying to evade it, but it is important to be aware if you have a quorum of your board attending an event, the fact that they're there, if some of these other elements then apply, the Open Meetings Act could very well apply, and you need to be aware of that. We've already talked about conference calls and simultaneous interaction, but be aware too, and this has been an issue a bit more recently, within the last year, electronic communications, or I should say last summer. As you get older, you think things are just a couple months ago, and it turns out that they're a couple years ago. I'm told that happens with decades as well, but we won't get into that. Electronic communications allowing continuous and interactive group deliberation on public business. The point there is that may not be strictly simultaneous, but it is continuous, and there is conversation and deliberation going on that the board has held that can be subject to the Open Meetings Act. Virtual meetings, as we have discussed, certainly. Social gatherings and retreats when public business is discussed. And be aware, retreats. Many times there's a question, well, if it's a retreat and we're not going to be taking any action. No, it's not just taking action, it's the discussion of public business. And a retreat is intended to be planning ahead. Now, that doesn't necessarily mean at all that the public has to have a right to participate. The Open Meetings Act concerns access and giving the public the right to observe or listen in if it's a conference call. Participation is not necessarily required, but what it does mean, if you're doing a retreat, you need to have some extra space for the public to attend. That is, if it's in person, and if it's nowadays, they need to have the ability to dial in or at least observe via Zoom, Google, or whatever you're using. Also does need to be pointed out, doesn't cover social gatherings if no public business is discussed. If it's purely social, if it's, just at a restaurant or a bar back in the days when we used to be able to do that, that's not going to be a problem as long as no public business is discussed. Next slide, please.
So I'm going to get into a little bit more detail on electronic deliberations of public business. Further going forward from what Frank had just discussed, when you transmit information by email or text messages without discussion, that's an acceptable means. So for example, if you're sending along, this is a document we're going to be discussing at our next meeting, just sending that by itself is not a violation, even if it goes to a full membership of the board or commission, whatever you're sending it to. If you're replying to say, I'm not available that day, do you think there might be another date when we can all get together? That's a scheduling thing. That's not really going to be subject to the Open Meetings Act. It's not a deliberation, even if it's to all folks. However, when you start getting into deliberations of public business covered by the Act, even if it's by email, particularly if it's near simultaneous, where it looks like it's an ongoing discussion, and that happened in a recent case where there were emails over the course of, I think it was about a 48-hour period, to asking the board, or in this case it was a county council, to take action very quickly on some pending legislation in Annapolis. and there were discussions back and forth amongst some, but not all, but everybody, or many of them were included on a lot of the email chains. The board did hold that to be a near simultaneous communication. That was a deliberation that should have been subject to the Open Meetings Act. So the question then became, from that particular public body, well, what are we supposed to do when faced with an immediate need to make a decision? And then we go back to, well, you can always, with a quick public notice, set up a telephone conference and then have the public observe that deliberation. So that would be a way to avoid that scenario. The Open Meetings Act board does recognize when things have to be done in a hurry, but each board or commission, each public body needs to adapt to those circumstances. So there is some flexibility built into the system. There have been efforts to draft legislation and have all electronic communications covered, et cetera. I'm overstating a little more detail, the nuance in that, but the point is that it comes back to the table very often that maybe there needs to be regulation here. Currently, at least a year ago when I was on the board, the position was, let's look at it on a case-by-case basis. We believe there's enough guidance out there to do that, to provide flexibility, and then to give the public bodies guidance going forward and how to handle their different situations. So another scenario that came up recently was the use of text messages, which is also very common. Where it really can get sticky is when you have a public body that's currently in a meeting deliberating public business, and some of them are getting text messages from third parties that aren't before the public body. Some of them are text messaging each other on the very issue that is before the public body that evening. That was a very tricky one for the board. I think with respect to one communication, it was felt that that was a violation because it went right to the heart of the deliberation that was at issue. The other one was not deemed a violation because in that case, it didn't seem to even be considered by the particular public body member who it was directed to, and it wasn't shared with anybody else. So again, that was very difficult because we were even picking apart which text might be an evasive device or not. So be very, very careful. I recommend to the public bodies, I advise don't use text messages when you are particularly on the dais, but even when you're not, if you're dealing with a deliberation and you're sending it to more than a quorum of folks or using it as an evasive device. So it's always best to err on the side of deliberating in public, whether it's through Zoom and video type calls or telephone conferences, which can be set up relatively quickly. Next slide, please.
And I would just say, and April gave an outstanding presentation on that, and partly because she was really part of the board in deciding on that issue. The main thing is, when you're using these reply all and the texts that are going to everybody, when that crosses the line into deliberation, that's what the act covers. If it's deliberation and discussion, as opposed to simply saying something like, where's the meeting going to be located, then that needs to be part of the open meeting. And the other thing, there were a number of local officials and attorneys who were not too happy with the board's decision on emails and continuous emails. But the board had warned for a few years, we don't have the right scenario yet, but the right case is going to come. This is a concern, and there were warnings. And I know many of us would always advise our local governments, if this is going to happen, let's not give them the option for us to be the ones. But in any event, just to add to the additional slide, and I believe this slide, April, is yours, so I will now be quiet.
Okay, so this is the next item of discussion is what topics of discussion, or also known as functions, are covered by the act? What's the scope? So generally, the act applies to advisory, legislative, quasi-legislative functions. They're all specifically defined. Now that might sound easy, but sometimes it gets a little tricky depending on the particular function of that public body. For example, excluded from the Public Meeting Act or Open Meetings Act are administrative functions. Now that's formerly called executive. We do not use that term anymore. We look mostly at administrative functions. as well as judicial functions and quasi-judicial functions. Although excluded from that would be things like planning commissions and boards of appeals, which have their own requirements for public hearing requirements, which may be deemed quasi-judicial in some format, or even administrative, depending on the public body. But those are excluded generally from the exclusions to the Public Meeting Act, Open Meetings Act, I'm sorry. So administrative gets tricky because that sometimes people want to put everything under the administrative rubric. Administrative would be things like agenda, setting an agenda. It would be something like if you were an ethics commission, it would include the ethics commission application of the law that they were given to consider under the ethics rules in a particular ordinance. If you're a commission formed under city council, for example. And then expressly included, I mentioned granting a license or permit or many land use matters. Again, they're covered with a kind of a different set of rule because they're subject to land use and zoning hearing requirements. So those are accepted out, or they're included in the Open Meetings Act. They're not excluded as judicial, quasi-judicial, administrative. That's the better way to say it. So that can get confusing for people, but the key is to look at the express definitions, walk through it, and then the Open Meetings Act opinions are available on the Attorney General's website, and that helps to clarify. But the kicker is to not include everything to be administrative just because you think it to be so. It may not necessarily, you may think it in your mind that it is, but when you start looking at the definitions in the Open Meetings Act, that's not necessarily the case. And Frank, did you have anything you wanted to add on that point?
No. As far as land use, actually it does specify that any other zoning matter is subject to the Open Meetings Act, so that if you're dealing with land use, almost everything is going to be subject to the Open Meetings Act.
Right. Thanks for clarifying.
Sure. And next slide, please. There we go.
Okay. So the administrative function, I touched on that a little bit. It formerly was called the executive function. We will still see that sometimes today in some of the complaints before, or the responses to the complaints before the Open Meetings Board are no longer there. But when I was on the board, we would see sometimes the respondents use the word executive function. It's not used anymore. It may be used in other places, but not with respect to the Open Meetings Act. It doesn't really have any meaning under the Open Meetings Act currently. The topic, and it's almost like this is if it doesn't fall anywhere else, then it's administrative. So that's one way to look at it. The public body must not be applying existing law or policy. It can't be creating law or policy. That would be the example I use for the Ethics Commission, where they are applying the existing law, the ethics rules, to a complaint before it. That would not be subject to the Open Meetings Act because it is deemed an administrative function. Note that an administrative function is different than closing a meeting because it falls within a closed meeting exception. We'll get to that later in the presentation, but that is a distinction that you need to know the difference. The meeting, however, might be subject to reporting requirements, and that would be, for example, if you go from an open meeting and then you're going to go into an administrative session, then you would need to state publicly that you're ending the open portion of the meeting and you're entering an administrative function. In that particular case, you would need to report that to in public if you were doing that. And then you cannot use confidentiality reasons to say you're in administrative session. That basically falls under the closed meeting section of the Open Meeting Act, and whether or not it's something subject to attorney-client privilege, which we'll get in later. But confidentiality by itself is not a basis to claim that the function is an administrative function. Next slide, please.
And we wanted to especially emphasize, again, the elements of needing to conduct virtual meetings just because of what we're all facing. Advanced meeting preparation may be an administrative function that doesn't require and isn't subject to the Open Meetings Act, but only under certain circumstances. And we want to make sure to lay those out for you. First of all, if it's a matter of how to link in, how to make it work, who speaks when, and how do we operate this, which are very legitimate considerations to deal with up front, and we'll touch on that a bit too. that limited discussion is certainly acceptable. So we're talking about the details of the process, protocols, setting the agenda. If it's that limited, it wouldn't require what we've been talking about, notice, a motion to close, or minutes, unless it happens to occur, as April was saying in the previous slide, in the midst of a meeting or at the end of a meeting. So if it's something that's lets everybody log in a half hour before the meeting, make sure we're hooked in, make sure everything's operating, that's understood, that's fine. Do note, though, that the exemption doesn't allow you to cross that line and start talking about the creation of public policy. So just be careful about that. Next slide, please. So in terms of running a virtual meeting, it says during COVID-19, but as we had said, this may continue, using elements of virtual meetings may continue beyond that. It certainly has required us to learn a new way of proceeding, and it may be that now having a virtual meeting doesn't require as much preparation because, for good or bad, getting used to some of this. So when running a meeting such as that, though, it is important, don't take it for granted. Proceed deliberately, carefully. Every meeting, even if I just said we think we're getting used to it, bear in mind there's public observation. Observing a virtual meeting can be a bit hectic depending on how many screens somebody's observing all at the same time. So we recommend, this isn't part of open meetings, but more practical suggestions. Being careful, start with a roll call, identify everybody that's there. Before speaking, speakers need to be careful to identify themselves. The chair needs to recognize, okay, this person is now recognized to speak. Raising hands can be helpful. Motions need to be very deliberate. Again, don't take it for granted. Raise hands to make the motion. There needs to be a second. What I have seen often on voting is not all at once. I mean, for instance, approving minutes, that might be appropriate, but generally what I've seen is, okay, each member to make sure we get it right, to make sure it's not only a matter of we get it right and that our minutes are correct, but bear in mind people are observing so that people understand who's voting for what. And then the chair does need to be very careful to maintain control, announce the motion, the second, and who is voting. It does put a burden on the chair especially, but it's just a matter of being very deliberate as to the steps we're taking. Next slide, please. We're back to April.
Okay. I think we have a few questions, Frank. This might be a good time to take some questions.
Sure.
Okay.
Yes.
I'm looking on my chat.
Thank you, April and
Yeah,
Frank. You can't see the questions, so I will read them to you, just so we don't have a big backlog of questions at the end. And you've kind of addressed some of these, but I want to make sure if there's any other details to give that you can. So the first question is, what if the public cannot join the call to ask questions? Not sure if that means technical issues or other barriers.
Yeah, the Open Meetings Act, and you know, I don't want to cut April off in any way, but the Open Meetings Act covers observation. So as long as, in terms of satisfying the Open Meetings Act, as long as there's accessibility to observe, that satisfies the act. In terms of participation, that may depend on, if there's a requirement, that may be a local requirement, that may depend on, let's say you're making a zoning text amendment or something like that, that may require it. And if it does require it, we're going to talk a little bit further about some other practical options. So I don't want to take a lot of time on that, but there are some additional steps that you can take to make sure there are additional options, because even in the midst of a public hearing, as we were talking about the need for the conference call as a backup for virtual, you can have difficulties or problems, and there are some steps we recommend on that.
I would just add, if it's one person that can't get on because they're having a technical glitch, that's a little bit of a different scenario than if the public meeting is being held and that public body system is breaking down. the rule is it needs to be generally available to the people who you would expect to be observing. So for example, if you're in a rural area and all you have is an internet Zoom type of call or Google Meets or something like that, but most of your community does not have access to the internet, that would not be something that would be generally available to the public that would be watching your particular meeting. So a phone conference call might be more suitable in that jurisdiction. On the other hand, if you're in a jurisdiction where nearly everybody has internet, you provide either an in-person place to also observe and/or the conference call, you should be okay with that. So again, it depends if it's just one or two people that can't get on because their own glitches, or is it something endemic in the type of technology selected by the public body that is preventing public access.
Thank you. We have another question here. When should the public be required to participate and not just listen?
Well, I think I had touched on that. The Open Meetings Act doesn't deal with participation. That would depend on your local rules, the issues that are before the board. Usually when there's a zoning change, well, if there's a zoning change, there are other elements of state law that would require what we would refer to as a public hearing. And generally a public hearing does allow a measure of public comment. Now that comment doesn't necessarily have to be always speaking comment, that can also be written, but and it doesn't require necessarily in person, because the speaking can also be virtual. We do have a slide where we'll talk about some of those options down the road as well. But if there is a requirement for participation, that's going to be more of a local requirement or based on the issue that's being discussed. It won't be an Open Meetings Act issue.
Thank you.
Correct.
Sorry.
Yeah, I just wanted to confirm that Open Meetings Act does not deal with public participation, and that goes beyond the scope of what the Open Meetings Act is handling.
Okay, we'll do 3 more questions before I'll turn it back to your presentation. Do the actions of a board, you talked about conference calls earlier, but this is like more of a follow-up. Do the actions of a board during a conference calls have to be ratified at some point?
If a conference call or a virtual meeting, let's just cover it all in the same way, as long as there's public access, that's the meeting. So they could make a decision at that time. There wouldn't be any other, like in our current situation, if you had to ratify what you do at a virtual meeting at an in-person meeting, optimistically that might be sometime next year that would actually be safe to happen. The point is that these meetings do comply with the Open Meetings Act, including a conference call, so that decision can work from there.
Yeah, and I would also add there might be something specifically in the bylaws of the organization or their internal rules of operation that might require that.
Sure.
Or something like that, Robert's rules. So I would always look beyond just the Open Meetings Act to see if ratification would be required. But assuming that you would be permitted to hold a virtual meeting under those other governing rules, if you will, then the Open Meetings Act would, from its standpoint, would view it as an actual meeting that you would be allowed to take active vote on.
Next question. What or who is the designated trainee?
I think I would say we will be getting into that with a couple of slides down towards the end.
Okay. All right. And then last question before we'll go back to the presentation. This is from the city of Baltimore. We found that having a virtual meeting with a call-in number has actually increased public participation due to the convenience of instant access.
What I said.
Yeah, and we've heard that a lot as well. We also record the session and post on our webpage so that the meeting can be watched later. So I guess that one's more of just a suggestion and insight. Let me make sure I'm not missing anything on that one. Nope, that's it. So yeah, just reiterating your point.
Mm-hmm.
So how about April and Frank around 11 o'clock? We'll come back on and take a few more questions, or I'll come back on.
Good.
All right.
Okay.
Thank you.
Okay, so the next topic is what actions do you need to take before a meeting? I mentioned earlier in the presentation that what you need is public notice. That's one of the things you need to do before. The timing needs to be reasonably advanced. Last minute meetings, they can be done. You need to make extra effort. So wherever you normally post your minutes, or I'm sorry, your notice, you would need to take extra opportunity, send out an email blast to your public who typically would be observing that public body. In one of my public bodies uses what they call a CTY, which is basically a robocall providing information. Such and such body will meet on this date at this time to take up this particular question. Send it out through a phone call. You could use text messaging. You could post it where you typically would post it in the front of the building where your public body meets. You could put it on the website. So if it's going to be last minute, we recommend that you take as much extra care as possible in getting the notice out. One of the things that when I was on the board that we would find, and it was frustrating from our standpoint, but I don't think it was intentional so much as the websites lagging behind where the public bodies were in terms of the use of technology. So there would be a public notice posted and you couldn't find it on the website. It would be hidden on some link somewhere, or there was a public notice on one part of the website and then the agenda would be posted on another part of the website. So they would be like, oh, we gave public notice. And we're like, but nobody could find it. So it needs to be accessible to the public. Just by posting it somewhere obscure is not going to necessarily satisfy that requirement. And then the content of the notice needs to have the date, time, place, whether it's open or a meeting, or whether or not it's going to be open just to take a vote on a closed meeting. And we'll get to that shortly. And then you also need to have your agenda, make it available in advance with the topics to be discussed. And also, you need to be consistent. Like I said, if you can find it one week and not the other, that's going to start raising flags. So you need to be able to find the notice. Next slide, please. Hold on a minute, I got it. I apologize, my computer was running down. Some technology glitches. Okay, so advance notice of virtual meetings. Similar to what the regular meetings would require, a lot of public bodies now have moved to virtual meetings on a regular basis. So if it's something out of the ordinary, again, you need to make extra efforts, just as if it were going to be a meeting that was held for like an emergency purpose or really quick notice. So you must also tell the public how to access the meeting. If there's a dial-in phone number, if there is, if it's going to be able to be viewed on Google Meets or YouTube for live stream, you need to make the public aware of that. We also recommend a conference call option, even with the live stream or anything like that. And as we just heard from Baltimore City, that has actually increased public participation. So that really goes to the heart of what the Open Meetings Act is about, is to allow that public observation in the meetings. So that's been really important in terms of allowing access for people. And let's see, so yeah, as I said, advance notice is critical. And if you have advance notice but nobody can find it, that's going to hurt you if you ever have a complaint against you for Open Meeting Act violation. So that's a pretty basic one that most people can comply with. Next slide, please. And then what actions do you take during the meeting? Well, you need to know where your location is going to be. If you're expecting a very large public outcry of a particular issue and you schedule your meeting in a really small location and need to keep people out, that's probably not going to be your best choice. If somebody complains, it's going to raise some red flags. So you want to make sure your location is appropriate to the expected attendance of your public body in terms of observation. Public participation is not required. We've said that before. Cameras, tape recorders, anything like that that's used at the public meeting, that is up to the public body. And those, we recommend model rules that are available on the Attorney General's website. We've adopted them for some of the public bodies I work with, and it really helps things go smoothly, and everybody has advance notice of what the policies are with regard to cameras and tape recorders. Many of the public bodies that are doing live stream now have a public recording of what they live stream, so that's also helpful. Any documents and communications are referred to during the meeting regarding access. That's typically by the public body. The Open Meetings Act does not require documents per se, but as a general rule, the bodies that I've worked with, if they're reviewing documents, those documents are generally available to the public for review prior to or during the meeting. And then the discussion must be audible. You can't have sidebars, quiet discussions while the deliberations are going on. It all needs to be heard by the public body. If there are amplifying means that would help people hear, that's helpful. But you can't have, okay, I'm going to have this recorded here, or I'm going to have this on the microphone, and then I'm going to go talk over there. It kind of defeats the purpose. Now, that's not to say you can't have, sometimes members will kind of do side notes to each other. What was the name of that thing we're voting on? Or what's the acronym or something like that? They might not catch something that's going on. That's different. That's just informational. But if you're going to do deliberations of business or discussions like that, that should be all done in the public work by which the audience can hear. Next slide, please.
We wanted to underscore the importance of public access for a virtual meeting because we're throwing the terms virtual and conference calls around. Again, to underscore the meeting's got to be reasonably accessible to the public. Now that's reasonably accessible. That means to the community being served, at least that's generally how it's been interpreted. That means giving some thought to the community that's being served, how do they access the meeting? Do they have the means to do so? For example, having a Zoom meeting or using some other online process without any conference call option may not be considered access or accessible for a community where people have limited computer access. We may say today there aren't too many where that's a situation, but that consideration does need to be given. The other thing we would recommend, again, as we had said a couple times earlier, allowing that conference call backup, make sure it shows that there's an extra effort to maximize accessibility. That's really the point. That also provides a practical backup if you have a problem. And again, when you have the Open Meetings Compliance Board saying that the conference call option can work, there's a measure of just being smart to include that as a backup while you're also ensuring access to more people and if there is a problem. Next slide, please. So in terms of the access options, what are we talking about? Well, for a conference call, that's usually going to be a telephone number, along with any access codes if that is required. For electronic online, that's going to be a code, usually a link, allowing participation. Sometimes it may be a telephone number to allow listening as an option, or as we had mentioned before, if there's software failure. And again, to ensure public access, an electronic online meeting can at the same time also be shown live via cable access and YouTube. Again, additional efforts to ensure more wide availability. Again, that's the Open Meetings Act concerns access and the ability to observe. That's maximizing that ability. Again, highly recommended if those backup options or those additional access options are available. Next slide, please.
So the other consideration during a meeting is whether you're going to be closing a meeting. There are several ways you can go into a meeting originally knowing it's going to be a closed meeting. A closed meeting can occur during an open meeting, or it can occur at the end of an open meeting. But in any of those three scenarios, there are still specific things that you need to do. First, you need to identify a specific exception to the Open Meeting Act. Those exceptions are set forth in 3-305 to 3-306C, and we'll get into those in a little more detail. But if you don't find a specific exception, then if you're going into a closed meeting, you're going to find yourself in a difficult scenario, because the Open Meetings Board will look at whether or not you've met with one of those exceptions. Again, trying to categorize something as an executive function is not going to fly. An executive function, first of all, that word's not used anymore. We use administrative, but just because something is executive does not mean it's subject to being a closed meeting. The other thing you need to do is complete a meaningful written closing statement, and that needs to include the citation of the section you're going into closed meeting for, the topic, the reasons for excluding, and also the chair has a duty to prepare and sign it. Holding a public vote to close after the proper notice to the open session. This is a little tricky, but I think many public bodies have gotten the hang of this. If you're going to go immediately into a closed session, the Open Meetings Act requires you first to hold the vote to close the meeting in a public session. So you notice your meeting. In your notice, you can state the purpose of this meeting is to go immediately into closed session. You start the meeting as an open meeting, you vote to go into closed session, you have the closing statement available there for review by the public. And that will satisfy your requirements as long as you do everything properly. But the whole point is that first vote is to open session, vote to close, and then you go into closed session, and then there are other reporting requirements, which we'll get into. If you stay within the exceptions in the closed meeting of what you closed for, in terms of that exception, that's all you're discussing, you're good. What happens sometimes is in the closed sessions, the body will go beyond the scope of what they closed for. Again, that's another basis for considering that the Open Meetings Act is violated. Then you need to decide on post-meeting disclosures. There's a public reporting requirement, and there's also confidential closed minutes. So both will need to be prepared. We have on the Attorney General's website actually has 2 model closing statements, which are very helpful. There's also a checklist. Also, you require to have a designee trained in the Open Meetings Act on your public body. If you do not have a trainee on your public body, you're not allowed to go into closed session. So it's very important to have your public body have a trainee on that public body. Next slide, please. So additional actions, here are some of the closed meetings that are narrow, closed meeting topics that are narrowly construed. One of them is personnel matters regarding individual employees. Basically things like hiring decisions where a person's credentials are being considered, or if there's a personnel matter where somebody's being disciplined. Those are things that are very sensitive. Those are allowed to be held in closed session. If the public body is receiving legal advice, that would be something covered, although you have to be careful. It's not just talking to the lawyer in a closed session about what is basically the business of the public body. It really needs to be, seeking legal advice, sometimes on a matter right before the board, sometimes on peripheral matters that come up during the session, but that would be a valid basis to have a valid topic for closed meeting. Litigation is a very common one. It needs to be pending or actual litigation. It can't be something that might happen. It needs to be, something that looks like it's going to be filed or is already filed either by the public body or against the public body. Real property acquisitions are subject to the exception, but not sales. So be careful on that one. That tends to confuse some public bodies. Collective bargaining, certain business development proposals, certain public security matters, particularly how you're going to handle certain crises might be something you might not want the public to view. It could be detrimental to the public body if the public knew exactly how things were going to be handled in certain scenarios. So you might want to keep that for closed purposes. That would be an acceptable reason to close a meeting. Cybersecurity is another one specifically identified. And then there's other laws requiring confidentiality. There's other exceptions also noted. Next slide, please.
And this is the slide we're going to reach on the question of handling public participation. Well, again, just to underscore, the Open Meetings Act really doesn't require it, but it can be required for public hearings, open public comment. There can be some other specific requirements. It can also be a habit of your local board to allow general public comment. Well, if you have that on the agenda item and that's always been there, there may not be a statutory requirement for it, but based on practice, you're going to want to try to satisfy that. Processes should be consistent and allow as much equal access as possible. The focus needs to be on maximizing opportunity. Again, these are not Open Meetings Act. We're not saying this is going to be a violation of the Open Meetings Act. It wouldn't be, but just the practicalities. You can, for instance, you can schedule oral comment. That the next slide is going to talk a little bit about the importance of scheduling that in a virtual setting, because not everybody can speak at once. They can't in person either, but it's a little easier to control when we're in person. We can't take that for granted virtually. Allowing an email option. In other words, sometimes it can be a matter of, well, let's do the public hearing, let's take the public comment, and let's keep the record open for 2 more weeks, or until the next meeting, whenever that's going to be, maybe the next week, to allow that option. Again, what you see there is maximizing the opportunity. If one option didn't work, there's another option available. The right of cross-examination in contentious hearings, that can be a challenge. Open meetings is one thing. Public participation is another level. Cross-examination, because you, by definition, have 2 different entities involved. Generally speaking, that can work. I've participated in a couple of local board hearings, and I know that some other folks have participated in court hearings where it's something that over time you tend to get used to. It does require a chair, or if it's judicial, obviously a judge, who is going to control the flow and who's going to make sure it's very deliberate. This person is now speaking on this topic, this person on that topic, and these are the folks that are having access and who can speak. Next slide, please. And this, to some extent, underscores the issue of public participation. In person is not necessarily going to be required. Prior notice and access details, just as we talk about for the meeting itself. Scheduling allows the speaker to comment in the order received. That can also be very important because, again, not everybody can speak at once. And then I had mentioned earlier the email comment and the importance of that. Next slide, please.
So we spoke about what you need to do before meeting, what you need to do during meeting. Now we're going to touch on what you need to do after meeting. So what are the actions you need to do after meeting? Under 3306, one of the things you need to have is meaningful minutes. They're required to be timely, and they're required to capture the actions of the public body. Open session meeting minutes should be available on request without redaction. That's pretty typical of most minutes. You can post it online if practicable. That's a new requirement. Most public bodies do have access to a website or something like that to post minutes. Where it can become a problem is if you have an ad hoc committee, or that not an ad hoc committee, a subcommittee or some other group that doesn't typically have a staff person assigned with them to get these types of things out there. We had a scenario where there was, I think it was in the context of a Board of Education search committee that only comes up as needed. And there was no ability for them to post the minutes anywhere. And they meet infrequently, so it wasn't like they had a regular staff person they worked with. So that created a little bit of a problem. So in that case, we had some recommendations to try and kind of pair that public body up with somebody who could assist them in posting minutes. It's also important to note that a tape recording does not equal minutes. So for those of you who are tape recording, they need to be transcribed in some manner, either in the form of minutes or as a transcript of some sort. You can't just have a tape recording. If you have closed minutes already mentioned, they should be sealed, and then you have the open session version available for public view. This also includes having sealed minutes for administrative function sessions that are not open to the public. That would be the reporting requirement I mentioned before. If you went into administrative session during or at the end of or at the beginning of a public meeting. You can use live and streaming audio or video for open session minutes. However, that can be cumbersome if you have to listen to the whole length of the meeting to understand what happened. So from a practical standpoint, I don't know many public bodies doing that, but you can do it. But I think many of them still keep written minutes, at least as a summary of the session, and then the live stream recorded minutes become kind of a backup. And then if you do the summary of the closed session, there are 4 required elements, and those are contained in section 3-213 of the Open Meetings Act. And there's also a compliance checklist, which is very helpful. I recommend our public bodies use that. It really keeps you in line on what you need to do. And those are the things the Open Meetings Board or Compliance Board, that's what they're going to look at to see if you comply with it. So why not use the form that they recommend using? And that helps keep everybody in line. And it's a very good teaching tool for your board members, your public body members, to figure out what they need to do. Next slide, please. So the minutes of the next open meeting should include the purpose of the closed meeting. Oh, I'm sorry. These are what should be available at the next open meeting of your closed meeting minutes, I should clarify. So they should include the purpose of the closed meeting, the citation of what section of the Open Meetings Act the closed meeting was held under. In other words, what was the function or the exception that could allow them to go into the closed meeting. That needs to be in the closed meeting minutes, the publicly available version of them. You also need to record the votes to close. Who voted to close? In some scenarios, it's not unanimous. Sometimes people don't want to close meeting. That needs to be recorded. The topics and the subject matter actually discussed. There have been some instances where the minutes of the closed meeting, even the summary version, indicated that additional topics were discussed, and that created questions. And when you look at the closed meeting, that can decide one way or the other whether or not you have complied, because while something might raise a question, when you actually look at the closed meeting minutes, you say, oh no, they didn't go into discussion. It was just, mentioned there. So you can actually confirm one way or the other, and that's why it's important to take accurate minutes. You also need to say if there's any action taken. Sometimes there's no action taken in a closed session. They deliberate and then they reserve their right to vote on that matter out in open session. That seems to be a fairly common way to handle some of those matters. You also need to state the date, time, and place, the person's present at the closed session. And there, again, there's a template. You can go on the Attorney General's website. And then the only exception to closing an open meeting for the administrative function, the minutes are more limited. You only need to include the subject matter discussed, the date, time, and place, and the person's present. You don't need to cite an exception and all that. So that's just a different requirement. It's still a reporting requirement. And again, that's only if you go into administrative function meeting during the process of an open meeting. If it's outside the process of an open meeting, that reporting function does not kick in.
April, would you like to take some questions? April and Frank?
Sure, I think it's a.
Sure,
Yeah.
we can. I think we're pretty close to the end, but that would be fine.
Okay, all right. Well, then we'll just do a few here. And you've definitely addressed a lot of these in different respects, but I just don't want to skip over any question to make sure there's any more detail. So is live broadcast on public access TV or radio an appropriate substitute for access by telephone to a meeting close to the public?
When you're saying closed, because if the meeting's closed, the meeting's closed. I think you're saying when the meeting, I'm assuming the public is not able to in person attend, that that can be an additional element to conducting it by conference call or more likely virtual. Yes, those can be very legitimate ways to ensure public access, to observe. Yes.
This next one is kind of a two-parter, or they go together. Zoom, Meets, Hangouts. Oh, wait, I'm sorry. Should we use multiple platforms? Zoom, Meets, Hangouts. And what if the public is not comfortable with all of these, but only one of these? We went from Zoom to Microsoft and then back to Zoom because not everyone was comfortable with the Microsoft platform. So I guess this is definitely a question for our current days. Should they use multiple platforms?
I don't you know, what we're saying, and you note the terms we're using, we believe that the virtual meetings can comply with the Open Meetings Act. The board decision we have is saying that conference calls can comply. I would not say, because a conference call is a telephone call, that's only one element. I wouldn't say there's any requirement to use more than one virtual program. A judgment needs to be made, because any program you use, just as any place you hold a meeting, is not necessarily guaranteed that everybody's going to be able to access the meeting when they want. People are going to have preferences for their own personal schedule. Virtual may in some ways help with that, as we've touched on, but in terms of the question's not going to be necessarily what's easier, what's the preference, but is it accessible? If it's inaccessible, in other words, if you do whatever, through whatever program, you do a virtual meeting and the codes aren't available or the codes don't work, you've got a problem. As long as the codes work, as long as people have the ability to access, to me that would satisfy, at least in general, the requirements to ensure public accessibility. If, however, you have a Zoom meeting or Google meeting where nothing's working, that's where the conference call option as a backup can still help you to be able to proceed and conduct the meeting, even if there are some problems. I think overall I would say options are good, and if there is a way to handle a meeting on multiple platforms, I mean, some of us are getting used to operating on one or another at one time with the conference call backup. But if there's a way to do it on multiple platforms, that's, again, enhancing availability and maximizing people's ability to participate. It's certainly a smart move, and maybe down the road that'll become easier as we get used to this.
Just wanted to add too that the Open Meetings Compliance Board has not ruled specifically on anything other. I'm just confirming on anything other than the conference call. But I do note some of the platforms do have, like Zoom and I think Google Meets, they do have, usually with the electronic computer access code link, there's sometimes, or I think all the time, there's actually a dial-in option. So within some of these platforms, there's actually a dial-in option already provided, and that may be acceptable to some. So I think you have to find what works in your community and make it reasonably accessible. And those are the things, as Frank said, making it as accessible as possible under the factual circumstances that your board is dealing with, or your public body is dealing with. I think those are the things that the Open Meetings Board would look at in determining whether there's been compliance or not. And that's where you're going to be able to present a good argument to the Open Meetings Compliance Board.
Okay. Well, I'll ask one more question, and then I'll let you all finish, and we'll come back to the rest of the questions. So, is a commission required to address issues of commission procedure or conduct in a public meeting, or is this considered administrative and can be held in a closed session?
Well, the famous lawyer answer to any broad question is that depends, and that would. That is one where, you know, in a general presentation and dealing with general topics such as we are, there's a lot involved. We had said earlier that manners of linking in and what number to call and what's going to be the agenda order are generally not something that considered administrative, and not really something that is subject to the Open Meetings Act. But there are certainly some processes and procedures. In fact, there have been some fairly recent Open Meetings Act Compliance Board decisions on processes and procedures that were changing some rules for public access, that not because public access is part of the Open Meetings Act necessarily, but it's a public issue if you're going to change the rules. So you're talking about a public matter. That process can be So again, it really does depend on what the specifics are.
And
In April,
I think, yeah, I would add that if the change in the rule is really a change in policy, that's what you got to. If you previously, if the public body determined previously that we're going to have public access and not just observation but participation, and then they make a decision, well, for policy reasons we're going to change that. That would be more policy oriented. Even though it seems like process, but if it's more policy oriented, that's going to lean more toward being subject to an Open Meeting Act discussion by that particular public body. So that's why the lawyer response, it depends. It really does depend, because if you're eking into that policy area, then it definitely would fall into the Open Meetings Act.
Thank you. I'll let you get back to your presentation, and I'll be back in with more questions.
Okay, I think we're ready for the next slide.
Yes.
Actions after a meeting, we're really dealing with record retention. And that's a legitimate question. For instance, the notice, letting the public know when and where the meeting will be held. But generally that's a screenshot of the online notice. If you are using internet to make sure people are aware, generally we would say, and there are some code requirements to specify 1 year. Minutes and tape recordings, what we have here is recommended 5 years. Actually, there's a provision of the Open Meetings Act that specifies 1 year for minutes. I'll come back to that in a second. Just want to go through these listing here. Sealed minutes, generally for 1 year. Closing statements, which are all part of the closing process, we would say likely for 1 year. But given all these timelines, there can be other laws that apply. The other thing I would say, and then in terms of access, they do need to be open and available at the office on request. Minutes should be posted online, and that is a code requirement to the extent practicable. So if you have, if your local government has internet access and has a website, once the minutes are, and that's not after the meeting's held, the minutes do have to be approved. The minutes should be approved really at the next meeting. They need to be posted. Unless it's impracticable, which would mean you don't have an internet or there's no way to post, which would be an unusual circumstance, or if you have some sort of data limit. Otherwise, they need to be available. Now, that doesn't necessarily mean that minutes for the last 12 years need to be immediately available to everybody. That's one reason why the code only requires the minutes to be kept for a year. That's how that prevents somebody coming in to ask for minutes from 2 or 3 years ago, and then putting the burden on the city staff or county staff to immediately produce something, or produce something very quickly. I mean, this is a matter of within reason. There can be a number of different boards, and it may be a matter of you can wait a minute. Well, you know, if it's the most recent meeting, it should be fairly quickly available. There can be some cases where, look, you know, you're asking for something that was 3 months ago, we'll get it for you. And if it's within a day or two, it should be fine. The one thing I would say is that this is referring to minutes in a specific context. Bear in mind, there can be other archiving requirements that do apply. I mean, the slide says that, but I'm underscoring that as well. But just because you can do something doesn't always mean you should do it. In terms of minutes, because you can destroy them in 5 years, and here's 5 years recommended here, but the Open Meetings Act specifies for minutes alone 1 year. It doesn't mean you should. In some ways, minutes are going to be your only reliable source of the actions that were taken by a board. If the board's purely advisory and it's a year-to-year matter where it may not matter down the road, maybe it's entirely reasonable. But for a county board, for a city council, to, once those minutes are destroyed, the record of actions taken, there may be another set of resolutions and ordinances. Certainly there's going to be a city or county code, but this isn't to recommend destroying the minutes. There can be instances where reviewing what has happened before, you find out. I know it's I would say in a prior life, at one point I was mayor of actually the town of Mount Airy, and had the idea in getting elected that we needed to have a town administrator. And the thing I was told was, well, we've never approved that. There's no such thing. There's going to be quite an approval process to go through that. Well, looking at the minutes, I found out that it had been about 40 years before that. It had already been approved. There was no deadline on the approval. Once it had been approved, the next issue was going to be, okay, we do have to pay for it. It does have to be a matter of the budget. Had those minutes been destroyed, I would have had no way of finding that out. And there would have been no authoritative source to say, no, this is the decision that was made, even if people had remembered. Next slide, please.
I wanted to just touch base on the minutes. You don't have to go back at all on the slide, but and one of the things that came up during COVID was what is reasonable practicality in getting the minutes available for the public afterwards. And one of the things the Open Meetings Compliance Board had discussed previously were, particularly with respect to boards that did not meet that frequently, how did they get their minutes publicly available if they're not going to meet well into the future? And then how did they approve their minutes? So one of the things the Open Meetings Compliance Board considered reasonable was if after the public body voted, after the public body met, if they weren't going to be meeting in the near future to meet this to the extent reasonably practicable standard, that they could approve. This is the one place when you can use email. You can approve by email the draft of the minutes, make that available to the public, those minutes. And then the next time you meet in person, either virtually or in person, the next time you have a regular meeting or a special meeting, you could approve the minutes. You could ratify that email approval. And then that email discussion would be limited to the approval and nothing else. And that was deemed to be acceptable. So I want to caution people on the use of that. But if you have a public body that does not meet that regularly, and you're running into this problem of making the minutes available and you don't meet to approve them, that's an option. So I believe there may be an opinion on that from 2018 or 19, I can't recall, but I believe there was a discussion on what does that mean and how do you get there if you don't meet regularly. So that might be helpful for some public bodies. So what are the remedies if somebody believes there's a violation of the Open Meetings Act? What are the remedies that the Open Meetings Act provides? Two. The first is advisory opinions, which is what the Open Meetings Compliance Board typically does, is they consider a complaint. There's no formal process of the complaint other than it's provided to the Attorney General's office, and I believe Ann McNeil is still a person over there, and under her are the people who would receive the complaint. In that case, it gets processed and there's a response that the public body can prepare and submit. And then the Open Meetings Compliance Board will review both the complaint, any documents submitted, including minutes, notices, agendas, any other material relating to the particular meeting at issue that's questioned. And if they find a violation, the public body must then summarize that opinion at the next public meeting, sign it acknowledging that they've received the opinion and acknowledge that it was a violation, and then return it to the Compliance Board. I mean, that was basically it. The Open Meetings Compliance Board does not have a lot of enforcement authority, but that is what they currently have. Over the years, there's been some legislative attempts to expand that authority. However, because it is only a 3-member board with no staff and being advised by a department, an office at the Attorney General's office, it was deemed that under the current structure, there was really no way to expand any enforcement. That being said, it seems that at least over the time I was on the board between 2015 and 2020, public bodies have taken more seriously their obligations to provide access, at least the ones I've seen that maybe had been in violation in the past, have taken more steps to make sure they had trainees on their board, more steps to consult with their attorneys to make sure they were in compliance. Whereas when I first started in 2015, there seemed to be more of a lackadaisical concern about whether it was complied with. So there does seem to be a little more seriousness today about it, because I think public bodies view it as in their benefit too. If they gain legitimacy in the public eyes when they're able to do things according to the requirements of the Open Meetings Act. The second route or second enforcement remedy that can be obtained is through circuit court orders. So under section 3, 401 and 402, the circuit court has jurisdiction and can overturn a public body's action in some cases. They can assess penalties, award attorney's fees. We haven't seen too many of these. There's a few, and they're very hard to bring because they're expensive, and there's no guarantee you're going to get an award of attorney's fees. You usually have to be successful. The circuit court may or may not take the Open Meetings Act Compliance Board's advisory opinion into consideration or not. They're not required to abide it, or the opinions did not carry any weight in that regard. They were just one more thing that the court could consider. So those would be the two recourses, and obviously a public body would have the opportunity to respond in any case and present its position that it did comply. Or alternatively, what we saw a lot with some of our opinions, the board would say, oh, we did kind of goof there, and we've since corrected our practices, and mea culpa, it's not going to happen again. And so that's really the goal of the Open Meetings Act, is to really gain voluntary compliance so we don't have to have the complaints. And that's the main, that's what fulfills the legislative purposes of public observation of the deliberations of the public body. So I think currently the remedies are adequate for the purposes for which the act was enacted. However, just be aware that there are movements sometimes to increase the penalties or increase the enforcement mechanism of the board. And we just don't know when that may or may not ever happen, but it's always a possibility. Next slide, please.
And just in terms of remedies, I would say that Ann McNeil, when she has presented and just in discussion with her, has said that when the act was first passed about 20 years ago, that sometime, or 25, I should say, that sometimes the discussion would be very informal. It would be a matter of a municipality saying, oh, we were supposed to follow that. There are some technical processes that the board may not want to find that, no, you didn't follow the exact process needed for a closed meeting, therefore you're in violation. It doesn't necessarily mean ill will on your part, on the board's part, but there was a mistake. She said initially it was understood, this is advisory, working together on this, that the board would say, well, we're sorry, we'll make sure to do it right next time. Now, complaints are taken much more seriously typically, and may involve in a 5 or 6 page letter from the city attorney, which I can say on Gaithersburg behalf, that would, when there have been complaints, that's how we respond to, because we're going to lay out what's happening. I mean, while it's advisory, the fact that it is public is taken very seriously. But while it was intended to be taken seriously, the intent was, let's get voluntary compliance. If there's a question, because there are certain provisions of the law that encourage counties and municipalities, if you've got a question, call us. We'll work with you. We'll see what we can do to get you an answer. So in terms of the training requirements, we had talked about the question that come up before, what's a designated trainee? There are a couple of different, there are at least 2 different training requirements, and partly it's because one law was passed in 1 year, probably about 8 or 9 years ago, and then the second law was passed more like 3 or 4 years ago, and they didn't bother to go back and revise the first one. So they're not necessarily inconsistent, but they don't mean the same thing. They do mean training, but the first training requirements here, which is that each public body needs to designate somebody, and this is the designation under this requirement, which can be a member, officer, or an employee to get training. They should get it within 90 days. And if that individual no longer serves or works for the body, it's not hard to understand, find somebody else to do that. Next slide, please. That's the first requirement, which would have sometimes staff getting the required training, because many times staff are going to be keeping the checklist and making sure everything's enforced. Well, there's an additional requirement. There's the more recent one, which does, and April had touched on this and talking about closed meetings as well. there is a requirement that the public body have a member that is designated. It doesn't mean only one member, and it doesn't mean also staff can be designated, but there has to be a member designated. If they don't do that, if there's nobody designated, and that designated member has not attended training, then that public body is not going to be able to meet in a closed session. Now, if that designated member, and as mentioned, you're not limited to one, so sometimes it can be sensible to have everybody trained. You can designate more than one. You don't necessarily have to designate everybody, but you could potentially. If that designated member, though, let's say there's only one, can't attend, because somebody was designated, because somebody got the training, public body can meet in a closed session, but they're going to have to use the compliance checklist that April had mentioned earlier, and that will have to be attached to the open session minutes. Here's a little hint. I would recommend using the compliance checklist whether somebody's there or not, because that way you're, again, it's maximizing your awareness that we are complying with the law. If we're following the compliance checklist, we're making sure we cover everything. There are some elements of technicality involved. In the midst of, many municipal meetings in particular are held late at night, last minute, 10:30, 10 o'clock, 11 o'clock at night. Is somebody necessarily going to remember everything? The compliance checklist can help you through that. Public bodies should, and this is really from the board, retain your own proof. You don't need to send it in that you have required the training. There is certainly a process and a designation. You will have that evidence, and just retain that locally is the requirement. Next slide, please.
So I've already touched. Oh, okay.
No, go ahead.
Oh, okay. We've already touched on some of the issues and common examples of what may happen. A lot of times it's these last minute meetings that can cause people to maybe not follow the regular procedures they normally do. And in those scenarios, we would recommend going over and above the notice requirements for holding the meeting, making sure you're complying with your checklist, your closing statement checklist. If you lack staff, for the example I mentioned before of the infrequently meeting public body, you might want to have a policy in place. What do you do when you have an infrequently meeting public body? Do you want to provide them with a staff person? Do you want to provide them with a place to post their minutes? Things like that might otherwise fall into the cracks. There was a scenario I saw recently where a public body did not know it was a public body for a while, and they were brought into compliance. It's like, oh, well, I don't know, I want to do that. Well, then the context of the public body changed. In other words, there was some turnover in personnel, because once they realized they were a public body, they didn't have an interest in doing that anymore. So it brought some new people on board. So that was kind of interesting. That was kind of an interesting impact of having the Public Meetings Act applying. It actually can bring more people into the process to participate in whatever type of work that public body does. Certain steps to avoid complaints, we've identified them. Some of them follow the 4 steps: identify the person responsible for the compliance tasks, include tasks on job descriptions, adopt a schedule for training, plan meeting topics, orient new members and staff. I have an orientation program I do with my public bodies. It kind of gives them an overview, not a formal training, but an overview of what they need to be aware of. And then if that particular public body requires them to get the training, they'll do that also on their own. So having people trained, and minimally, if they're not formally trained, at least knowledgeable, so they understand what the basic elements of the Open Meeting Act requirements are. Also, I can't strongly recommend enough, avoid the use of electronic or other non-public communications whenever you're including deliberations or discussions of decision-making regarding public matters, especially if it involves a quorum or if it's being used to evade the intent and purposes of the Open Meetings Act. That's where, that's probably we see. Now, that's not to say everybody who does that, as Frank said before, is intending to evade the act. Just be cautious that you could be inadvertently evading it, and it may result in a finding that you have violated it. I know in the situation of the Talbot County case where had the emergency meeting or the emergency legislation. It turned out in Annapolis, and they wanted the county wanted to take a position on it. It wasn't really such an emergency. We found out later because it had been pending for a while. It just, the request came in late for them to take a position. So yeah, it was short notice, but having it been on short notice, nobody was being accused of doing anything deliberately underhanded or anything like that. It's just that when you looked at all the circumstances in that particular case, it posed a problem and it violated the purposes of the act. And there are other cases that might be a close call and might end up the other way. It all depends on the facts and circumstances. So if you're very careful and avoid the electronic types of communications on anything remotely considering deliberation or decision making and policy making, you should be protecting yourself there as well. And then also respond to the complaint. There's procedures online. If you don't respond to the complaint, people are going to say, what's going on? You need to be concerned about how your public body's acting. If you have a defensible position, defend it. There are many cases that are brought that the Open Meetings Act Compliance Board doesn't find a violation. So, or the violation is so minor that it didn't impede the public in observing. There were a few cases like that. So if it didn't really impede anybody from observing, but it was a glitch, then it might not be that big of an issue. Like, it was only one person that can't get on the conference call, and it was from outside and you didn't know about it till after the fact, that might be a scenario. I'm just throwing that out there. But, so just try and do everything as along the lines of what you typically do, along the lines of keeping everybody notified, posting things timely, and making sure you have your people trained. And I think it goes a long way into preventing violations. And Frank, you want to insert a couple of examples there as well?
Well, I would say we talked about avoiding complaints, follow the 4 steps, and we didn't, this is a summary, we didn't really specify, are there an additional 4 steps? Those are do these 3 things that were in the early slide, which are advance public notice and an agenda, pretty basic. Hold the meeting in public, not going to be a problem. Prepare minutes afterwards, and of course have somebody designated for training. Those are the 4 steps we were talking about. That's generally going to insulate you from any complaint. Of course, holding a closed meeting is not the same as holding an open meeting, and we'd say follow the process. And that's really been what this has this whole presentation has been about. Another technicality, and April certainly did touch on it in talking about closed meetings and closing for one purpose. You need to be very careful to stick to that purpose, though. If you close to talk about property acquisition, that's going to be the subject. Now, if you're noticed for close, and if the decision was for property acquisition and a personnel matter and maybe getting legal advice, then those would be the 3. But if you only close for property acquisition, then it's not the time to talk about legal advice. When you cross that line, it's no longer a proper closed meeting. That's where it can help to have staff who are available and trained. So just because board members need to be trained, staff should be as well, because they can help the board to say, oh, we've crossed the line. We need to make sure not to go into that. We'd have to do another closed meeting because we didn't include that in the reasons for closing the meeting to begin with. Just some things to be aware of. That can be another situation where there was no intent to do anything wrong, but we do have to follow the process. Next slide, please.
Oh, can I just add one more thing?
Oh, sure.
On the closing of the meeting, the closed meeting checklist, the closing statement checklist, also has a section where you're supposed to cite the reason. And so not only do you cite the section of the code that you would fall under, so let's say advice of legal advice. So the reason would be is that discussions with an attorney are entitled to confidentiality under the attorney-client privilege. That would be the reason under the code section. So you also have to put the reason in there. That's another thing that sometimes the public bodies have failed to insert a reason in the section of the checklist. So that's another thing to be aware of. It's actually a separate requirement, and sometimes people won't separate that out. Next slide, please. So for more information, we've already mentioned the compliance checklist, the model closing form summary, frequently asked questions, the opinions. It is a wealth of information. I go here myself. Maryland Attorney General's website. It's a very good website for open meetings. It's got a separate tab just for open government. It's got an Open Meetings Act manual that was prepared by the Attorney General's office. Is basically a summary of the Open Meetings Act, and it cites directly to the sections of the Open Meetings Act that you would need to reference. So it's a very useful resource. Also for virtual meetings, Maryland Municipal League has a summary, which is very helpful. And Frank is very active with the Maryland Municipal League and has been very active in that area. And there's also resources, an online class at the Institution for Government Research. You can go there as well. So I think, Frank, do you have any more resources? I mean, that's a wealth of information right there.
Yeah, that's pretty much what we would offer. Certainly, I think we've probably gotten individual questions from time to time, and you know, the law that sets up the Open Meetings Act was actually written with the idea of, if somebody has a question, ask the board informally, and that has not been more lately how things have proceeded. But those are some very good resources to ask a question, and these generally for the Planning Commissioners Association. I believe this is the third or fourth year that we have provided this, and we will intend to, if we're asked, to continue to provide it in future years, so that the training is available and out there, and certainly make use of the resources. The AG site, the Attorney General site, is probably the most extensive for any questions that you would have. And I don't know if there are any remaining questions. We were looking at 1 hour. We're a little beyond that, but if time allowed, we also have, we do have the contact us, so we can try to do our best as well.
Mm-hmm.
Yeah, well, actually, we budgeted 2 hours for you, so we're doing well. Yeah,
we're in good shape then.
Yeah, and there are quite a few questions.
We're not behind. We're ahead of time.
You're ahead. So I'll get back to the questions. Should rules of procedure be sent out with agendas so that all attendees know if they're allowed to speak and how discussions are handled?
There can be so many different rules of procedure that may or may not apply, because there can be different rules for specific topics as well. For instance, state law may dictate certain procedures for land use public hearings, changing the zoning. So there may be an element of practicality that generally that's not done. However, when you do have, not every public body is going to have rules of procedure that are established, but when you do have them, I would recommend at least posting them. If you have an internet, and there's an internet page for a board or commission, whether it be county board, county council, city council. If you do have rules of procedure, I would strongly recommend posting them. In terms of, are they available for public review? That's not the Open Meetings Act. That's the Public Information Act, and they certainly are. But as far as sending them out, there's usually enough of an attachment for the full agenda package anyway. Having the specific rules, unless somebody has a specific issue, are they going to review it? So if it's online, give them that ability to access it. That's practical advice, but there wouldn't be an Open Meetings Act requirement.
Okay, thank you. And next one has references as well. Is an agenda required to be available to the public before a meeting? The AG's manual says that it's not required. Page 22, Chapter 2, Section B, third paragraph.
Well, I believe there's a code requirement. It could be that the manual, they're not updated all the time with to reflect the specific changes, and it may be that section is referring to a specific code, but there is an Open Meetings Act section requirement that does say 24 hours in advance, but that is not a hard and fast rule. That's also or as reasonable. The other requirement that applies here, or not requirement, but flexibility, is that you may have an agenda and it may be published, and that may be how you're operating, and in the middle of the meeting, you can shift things around as needed. We're going to be postponing that issue, or there can be a new issue that does come up. That's just part of the meeting. So what I would say is the comment that you cited, if that's an overall rule, that may not be fully accurate, but it's not necessarily inaccurate depending on the context.
I would just add that, yeah, the agendas can be changed during the meeting according to Robert's rules or whatever other procedures that the public body uses. So sometimes the agenda that's actually published and available to the public ahead of time may not be the agenda. And the Open Meetings Act is not, they don't really touch on that part of it. So I say what Frank says. I mean, it's not entirely accurate, but I've seen scenarios where the agenda's been changed, and that's not been an Open Meeting Act violation. So.
Yeah. Next question. Within the definition of observation, isn't hearing the meeting more important than seeing the meeting as far as observation is concerned?
No, I would say as long as you don't have a hearing impediment and need it somehow translated, but I think you can have that done by phone now, where you can have some sort of translation service. So I think the video without audio would be, I don't think it would be that helpful. So you need audio in either case. So yeah, I think that audio is the most important, clear audio.
Yeah, even though we're online, if you didn't have the audio, I don't think this would be all that helpful. I think you'd probably get tired of looking at it. Certainly you get tired of looking at me. But the board has held that a conference call in and of itself with no visual option at all can comply. So yes, the hearing part is certainly the most critical.
The next one is more of an observation. With the winter coming up, if a meeting is live streamed, different areas may be impacted due to bad weather, which may affect electric connections. Good thing to keep in mind.
That can be, we had touched on the public comment element. One way to try to maximize the availability for public comment that we were recommending was not necessarily making a decision the same night that the agenda item's on, but to say, okay, we've allowed a measure of virtual public comment, but we'll keep the record open for another week or two to allow email comment as well. And that might address that kind of an issue as well.
This next one might be cut off a little bit, but I will do my best. Is a nonprofit organization subject to the Act? Please distinguish between two scenarios. One, the nonprofit accepting public funds from local government, and two, I think it gets cut off, one that does not. Oh, maybe it just says one that does not.
April may have her some addition to this, but I would say when we're talking about the creation of a public body, and that was early in the training, we were talking about public bodies essentially created by the government entity, and there are some instances where there's a certain type of nonprofit that's actually established to assist the government. Receiving funds is not, in and of itself, would not be a reason to switch a public body, to switch a nonprofit to having to comply with the Open Meetings Act. It's more who appoints their governing board and who created it would be the key questions to take a look at. I mean, there's still an element of it depends. So yes, if it is a publicly created body and the let's say the city council appoints the board, well, the fact that they get some money may not be the key issue, but they're going to be subject to the act. But if you're dealing with, let's say United Way or an entirely separate nonprofit, and they receive some city funds, there may be other reasons why they'd want to conduct a particular meeting in public, but just the receipt of city funds, I don't see a scenario where that would do it.
Yeah, I agree with Frank. The receiving of the public funds is not the test. The test is, how is that body created? Does it fall within the type of public body that is covered under the Open Meetings Act? And there is a case, there's a reported opinion on this, I believe, and there's also a couple of opinions, advisory opinions, where the Open Meetings Compliance Board looked at how the board was created and who controlled the board members and the appointment of it. That was really important, and whether or not that appointment process fit within. So the more control that a government body or another public body has over that nonprofit, the more likely it is that that nonprofit would be deemed a public body. But absent some sort of control by another entity that would bring it within the formation of a public body in general, I don't recall seeing anything where it was only the receipt of the public funds that made something subject to Open Meetings Act.
Okay.
Now, Joe, I did get an email question, so I'll let you go ahead with yours, but I've got one more.
We've got no, we're not going to be able to finish. I will say that, but go ahead with your email question.
Well, mine is simply dealing with the cross-examination question. Doesn't the Open Meetings Act only require observation? And that's true. We were talking about public participation where there are other requirements that apply, and just dealing with the whole virtual open meeting in general, doing a public meeting virtually. And the cross-examination question came up as one that there are some requirements where some instances where cross-examination is a right. It's not going to be under the Open Meetings Act, but let's say if you have a particular planning application that may be before a planning commission, which is going to be an open body, or may even be before the city council or both, there may be some cross-examination rights on the applicant for that, and that would apply, but that wouldn't be an Open Meetings Act issue at all. I didn't mean to cut off any other questions you may want to ask, Joe.
No. Let's see here. Next one. If there has been a deliberation by email, how is that made part of the Open Meeting Act, or part of the open meeting after the fact?
I mean, I would say generally because it's not simultaneous by the nature of it, but it's going to be continuous. And if reply alls are used that include a quorum and there's deliberation on a matter of public business, those are the elements that are going to trigger the Open Meetings Act requirement. And certainly this is something that April knows a lot about as well, so she may have some additional comment.
Yeah, I go back to, it's very factually based. So even if you did some of that and there's a complaint brought, there may or may not be a finding that there was a violation. But I guess the best way to say it is, if you want to avoid any question, then don't engage in that behavior. So if you're engaging that behavior, you just run the risk that somebody's going to find out and say, oh, that's a violation, and then you're going to be subject to scrutiny. So in my experience, it's very fact-based. So it's hard to predict one way or the other what the outcome would be without knowing the actual discussions taking place. It really depends on that fact-specific thing of what are the discussions or deliberations under consideration. Was there a quorum present? How much of the quorum was involved? Were there reply alls? Were there, back and forth? In one case, we found that actual substantive changes to minutes were deliberations. So that's a scenario. If you say, can you change minutes? Yeah, you can change minutes. If they're substantive and they're not in the open, subject to an open meeting, that could be deliberations also. So again, it's very hard. It depends on the fact circumstances. We can't always paint a broad brush, but what we can say is if you avoid certain practices, you can make it less likely you'll have a complaint brought against you.
Next question. Does a meeting held simply to go into a closed session count against the legislative meeting limits of a legislative body?
I would say that sounds like a local requirement because we don't have any limits at the Open Meetings Act level. But I mean, I will take the opportunity to underscore, if you're going to choose to go into closed session, it needs to be in an open meeting. So you can have an open meeting where the only agenda item is to vote to go into closed session. That is a legislative proceeding. If it is a, let's say it's a county or city council, that would count. But how, if there is a limitation, how that adds up would depend more on the interpretation of that particular requirement.
How inclusive about statements made must the minutes be?
I have often told folks minutes are not a transcript. It needs, they at core need to cover the actions taken, or certainly in general the discussions had, but that can be that there was a discussion on X and Y. It doesn't, the minutes are not required to be a transcript to cover every element of this one said this, and this one said this, and then this one said that. Minutes don't have to be long, don't have to be extensive, but do need to cover what was done. And I would also say in terms of a motion, it's important who made the motion, who seconded, and what the votes were. But again, that's part of what actions were taken.
They also should include who was there, present, who was absent,
Sure.
You know, and then, yeah, I mean, there's no requirement. The basic Robert's Rules of Order minutes requirements, I've seen that. And some people take more extensive minutes, and sometimes that's good, sometimes it's bad. It really depends on the public body and what they prefer. I've tried to tell some of my public bodies to whittle down their minutes. They don't need to be that long, and they insist on keeping them real long. So it's some of it's just custom of that particular public body, but there's no Open Meetings Act requirement. I think the minimal elements that Frank suggested
Right.
are fine.
Okay. Slide 24 seems to contradict itself. Is a video recording of an open session acceptable as a substitute for minutes, even if it wasn't streamed live? I don't know if you need to look back at slide 24, or if you think you understand the question without it.
I'm only aware that, I don't know if the minutes need to be live streamed to be considered minutes. Do you know that in particular? I know you can't use tape recorded minutes. I don't know if the same is true for something that's not live streamed and recorded from a live stream, but I would say that if it's to be used as minutes, it should be live streamed, because that way,
Yeah.
we had a scenario, we actually had a scenario where there was a live stream, and there was, one of the public bodies I work with had somebody who said something unfortunate on the stream that probably wouldn't have been suitable for broadcast television, but the YouTube streamer said, I can't change that if that's the public record. So my thought process is that would be inclusive, but Frank, you might have more knowledge on that.
No, it's referring to a specific code requirement, and I think sometimes in our presentation we have said we don't recommend it, but if it is live stream, whether audio or video, that does need to be then of course recorded, but that live stream recording can serve as the minutes. And one of the reasons why it's not recommended is if you then have to check something in the minutes, you may have to listen to the entire audio or watch the entire video in order to get it. And the reason why it talks about audio or video is, you know, we had an earlier question, what's the most important, audio or video? Well, obviously the audio is the most important because that's what's actually said. So while the Act talks about observation, it's the focus is really on being able to listen in.
I'm going to do 2 more questions, I believe. But again, all the questions. Yeah, absolutely. I want to talk about the credits at the end too, real briefly. If a citizen knows they would like to cross-examine a witness or applicant, how can they do that when there is only the ability to listen or observe a meeting? Can they legally demand the right to cross-examine a witness in a quasi-judicial?
Well, again, it depends, because it may depend on the issue. It may also depend on your local rules. However, leaving all of that out, there are certain, that I'm aware of, certain zoning planning commission applications where there can be a right to cross-examination. But in many cases, a local ordinance laying out a right to a public hearing is generally considered public has a right to comment. But if the public hearing is about some sort of application, in many cases, the local ordinance with the right of cross-examination, that's going to establish that. In some cases, it may be implied, depending on what the application is, but generally in an application before a planning commission, let's say for a site plan, a development, the circuit courts have held that there is a right to cross-examination. But again, bear in mind, actually similar to a question we had earlier, that's not an Open Meetings Act requirement, because the Open Meetings Act does not cover participation. That only came up because we're offering some practical advice in handling open meeting, virtual presentations and virtual meetings.
Okay. And then the last question, this kind of gets into your electronic communications discussion. I'm assuming that it is a big no-no for PC members to chat privately during meetings on Zoom.
I would say yes, it just raises a question. I would also say when we have, sometimes when you do training, and sometimes that can also happen virtually, but I've always liked the in-person trainings because sometimes I learn as much as others might from me, just by the nature of the questions. And at a couple of trainings that we've given, there has been the response that in order to discourage that kind of thing, that they actually have local rules that say, you know, any discussion among members, because you can always text back and forth, or even if people are able to access email, not during the meeting. And that's partly to make sure that there is an Open Meetings Act requirement that if you're having a discussion about public business, that all needs to be available to be heard and observed, so that you can't have the secretive discussion behind the scenes, even if it's member to member. But you know, as April had said earlier, if there's texting on something like, where are we on the agenda, or how's your mama and them, which would be not even a public matter, that would be okay.
Well, great. I wanted to, before we switch over to Secretary McCord and begin the 12 o'clock period of our day.
I think he's ready.
He looks like he's ready. He wants to. He's a trained attorney himself. He might have something he wants to get in a discussion with you all about. This class is eligible for those pursuing Academy of Excellence credits. If that is something that you are pursuing, you would need to be logged. The notice I've gotten would be that you would need to be logged in for the entire session. And we'll have a recording, or we'll have a list of everybody who has been attending, and that you would need to complete an online evaluation form within the following 3 days, which we will send out to the group either later today or tomorrow for you to complete. Frank or April, do you have anything to say about, certifying that people took this class? If there's any, separate from Academy of Excellence credits, just the fact, you need to have somebody trained in this class. How do you want to go about doing that?
Frank, you want to take that one?
Yeah, that was in some of the what we had just said initially. That's not dealing with credit. That's dealing with the certification that somebody has complied with the act. And in asking directly, very similar to what you had just said, you got to be logged in the entire time. You need to complete an online evaluation form within 3 days. So this being Monday, by the middle of the week, you need to complete an online evaluation form. And there should be the online form that the planning department has. And if they don't, let them know, and they'll be able to get it to you, because it should be available. And that was being provided, I believe it was somebody from the Maryland Association of Counties who had that available. So that should do it. And in terms of the evidence you get, it should just simply be a quick statement that says you complied with the requirement for the Open Meetings Act to be trained. It's just a simple statement. I have one too, by the way. And that's not something that comes from anywhere magic, but that would be provided. I believe that would be provided by the Academy, and that just may be emailed. But other ways to get the training is also to go on the Attorney General's website, and that's where what would be printed out once you successfully take that training and pass. There's a required test as well. So we don't have a test for ours.
Well, thank you, April and Frank. This was great. We got to most of the questions. I apologize if I was not able to get to everybody's questions. And yes, this is the 4th year that you have provided this training, and
Okay.
MPCA really appreciates it. And we look forward to the future collaboration on that as well. But thanks again. I know that Secretary McCord will be up next. We've got a packed agenda, but yeah, we'll be in touch.
All right, thank you.
You're
Thank you
welcome.
all. Thank you, April, as well.
Take
Good
care.
to work with you again.
Mhm.